Chair Holvey, Vice Chair Barton, Vice Chair Kennemer, members of the committee. For the record, my name is Courtney Johnston, and I'm here today on behalf of the National Association of Social Workers. The National Association of Social Workers is the largest and most recognized professional association of social workers in the world, representing approximately 1,700 social workers here in Oregon. We work to advance the profession of social work, but in addition to those lobbying efforts, they also, their mission works to enhance the human well-being, particularly those most vulnerable in the community. About 8 months ago, they began to explore the issue that workers in the adult entertainment industry not only didn't get paid a wage, but in most cases had to pay to work. They asked us to explore this issue and see if this was if there were in fact abuses in this industry. We were put in contact with association member Stephanie Wahab, who is a professor at the Portland State School of Social Work and a foremost academic expert in the sex work industry. She was clear with us that the only way that our efforts were going to be successful is if we allowed this to be industry-led. And so she helped us get in touch with, or put together a panel of dancers in the industry. That panel grew into a larger discussion group, and from there expanded into a coalition to include musicians, comedians, many of whom are represented here today. We met several times to discuss this issue, and what we found was the vast majority of live entertainment workers are independent contractors. For many, there was no formal training in the industry. What they learned about their rules and regulations or their rights as workers came from their experience in the industry, from their peers in the industry, and in many cases from their managers. And that information wasn't always to the letter of the law, and it's not always in the best interest of the worker themselves. But a couple other things were made clear in these meetings that we held. First, they have very diverse views, which you're going to see here today. And we realized right away we were not going to tackle the issue of independent contractor versus employee status with this legislation. Many of these entertainers truly are independent contractors, and many of them want the freedoms and flexibility afforded to independent contractors, which I'll let them speak to. We also explored the issue of licensing live entertainers. But for this particular group, there was an understandable fear of stigmatization that can come from a traceable work history. Wow. So what you see for you here today is House Bill 3059, and that is the accumulation of our efforts. The bill would direct BOLI to create a poster detailing the rights of live entertainer independent contractors. The poster would be hung in entertainment facilities where all workers, contracted or otherwise, could access it. House Bill 3059 also creates a hotline that live entertainment workers could call anonymously with questions or concerns regarding workplace safety, wage and hour issues, possible illegal activities such as sex trafficking, or any other relevant issues. The line would be operated by someone with a background as a live entertainer, someone with a background as a social worker, someone with a background working at a crisis hotline. And to speak to the hotline for a second, I think that these are a unique category of workers, and whistleblower protections are not provided to them. So we thought that this would help provide those protections. And just in closing, House Bill 3059, it aims to improve the workplace safety for all workers, regardless of industry, to improve access to workers' rights information, and to provide an avenue to help curb sex trafficking. So with that, I'll close and let my other witnesses go.
Chair Holvey, Vice Chair Barton, and Vice Chair Kennemer. My name is Elle Stanger. I've been stripping for 6 years, primarily at the Lucky Devil Lounge in Southeast Portland. I've been very actively involved in the industry. I'm the longest running female columnist for Exotic Magazine and former assistant editor for the magazine. I've won poll competitions, judged them, produced events, and I currently do nonprofit efficacy work for sex work-related organizations. I published a collection of short stories last fall by strippers from around the country, which illuminates the diversity of not only the workers, but of our experiences. All of this is relevant because I may not be the epitome of the average adult entertainer in Oregon, but because of my broad reach in the industry, I've been privy to the best and the worst working conditions all over the city of Portland. Portland prides itself on being a mecca of art, culture, food, drink, and social activism, not even just for the state, but for the country. And yet, in our impactful industry of entertainers, there is no minimum safety standard or ethics standard for those workers. And why is that? I believe part of the reason is that much of
Can
the
you push the mic away just a little bit? It sort
Yes,
of
sir.
distorts when you're too close. Even,
Oh, okay.
even further than that, actually.
Believe it or not, I've never done this before, Chair Holden.
You're doing great.
Doing great.
Just
Yes, sir.
about 8 inches
Okay.
is about the right distance, because
Okay.
then it won't distort. Excuse me.
Thank you. How's this?
Thank you.
Good?
Much better.
Okay. I believe part of the reason is that much of the entertainment population in Oregon is comprised of adult entertainers. Historically, women and sex workers have been targeted for violence, silenced, or just generally oppressed. And still, as evidence before you, we are people. In my line of work, I've met some of the most enlightened, intelligent people, both patrons and peers. I believe that my work as an adult entertainer is valuable and that the demand for the supply is evident. These proposed bills for a tip line and for a written statement of workers' rights would reinforce the confidence of the entertainers, not only that their work is valued, but that their person has value. Many adult entertainers fear contacting conventional middlemen, such as law enforcement or lawyers, and an anonymous social worker staff tip line would remedy that. In my years in the adult industry, I have witnessed very few instances where I suspected that sex trafficking was occurring, and yet an available contact number would help to report those that we do suspect might be involved. I do not support the exploitation of individuals, and I do not want an otherwise consensual and legitimate place of work to be used for these crimes. In speaking with literally hundreds of adult entertainers, our biggest concerns tend to be regarding health and safety. In my 6 years of dancing, I have incurred numerous injuries, not unlike an athlete. In my place of work, I feel neither endangered nor exploited, and yet I have a litany of stories from my less fortunate peers who work in other venues. If I may read a couple.
Go ahead.
I quit club name years ago when I showed up for my shift, and a 12-foot by 12-foot pane of mirror had been broken out a month prior. The stages were filthy, but after 1 month, no one had bothered to clean up the broken mirror. Shards of glass gradually worked their way over the stage floor. Girls were getting cut up and risking staph infections. When I worked at club name, more shards of glass would fall from the mirrors and drop tiny shards on the stage. I've contracted staph and MRSA twice while dancing. Personally, I've contracted it 4 times. Being told that you're on the brink of death while suffering excruciating pain and racking up hundreds to thousands of dollars in medical bills with no chance of help from the club you were damaged in to begin with is a bummer. Clubs do not have any requirements to deal with mold in their establishments. You can see mold where the ceiling fell out in the bathroom almost a year ago, and when the heat is just right, you can smell it. I broke 3 fingers on a club stage when I was 22, and it took the owner an entire year to fill in the square hole around the base of the pole that caused it. There are hundreds of these. I personally have popped ribs out. I have glass embedded in my hand. I've had MRSA staph 4 times in 5 or 6 years. And I'd like to state that when I had MRSA, it was because I found out they were using the mop to mop the stage that they use in the men's bathroom. When I pointed this out to the owner, they got a new mop, and I've not had it since. I'd like to finish by saying that this is not a women's issue, nor a stripper's issue, nor just a worker's issue. This is a human issue, and I beg to ask why anyone would be opposed to improving humanity in any manner.
Thank you.
Chair Holvey, members of the committee, my name is Caleb Hayes, here on behalf of the National Association of Social Workers. I'm here to just help explain the amendments that are coming and tell you a little bit about our process. So we've worked with stakeholders, including Metro and the Portland Trailblazers, on some amendments to clarify the definition of live entertainment facility. Those will be incorporated in what most likely will be -2s. Right now, the -1s that we have get at most of the amendments that we needed. We will have an element in there that requires anonymity or allows for anonymity with calls to the hotline, and some additional language to get at what exactly is a live entertainment facility. With that, though, I'd like to thank the committee and everyone else who's helped along in this process. It's been a long road, and I appreciate the committee's willingness to take on this issue because it's important and it's long overdue. I also want to note that although our organization's name is at the top of the bill and that at the request of line. This isn't our bill. We're proud to have helped facilitate this process, but this is Elle's bill. This is the bill of everyone who's come together, workers in the industry who stood up for their rights and told us what they needed. And we hope that we can get this bill passed. Thank you.
Thank you. I appreciate it. Representative Barton, a question?
Comment, really. Thank you, Chair Hovey. I wanted to thank the social workers as an organization for bringing this forward. It's and I suspect I speak for many of us up here. It's always quite impactful when you see an organization lobby for legislation on behalf of people not in their organization. We saw it last week with the orthopedic surgeons in mental health. Not something in workers' comp, if you guys remember that. It's not something you typically see. Most organizations in this building, understandably and appropriately, lobby for the parochial interests of their membership, and that's fine. So anyway, I really appreciate that. I wanted to acknowledge that. It means quite a bit to us.
Representative Fagan.
Yeah, well, thank you, and good to see you all again. I really am supportive of this concept, as we've discussed in the past. In particular, the district that I represent has East Portland, and I know that Elle, you and I have talked about, those clubs out there being very different than a lot of the clubs downtown, where there is definitely suspicion that has yet to be proven of, serious kind of sex trafficking, human trafficking issues going on in some of those kind of East Portland clubs. And so I'm a huge fan of this hotline to be able to potentially at least hopefully shine some light on those situations. I am just on a technical level curious about the hotline, because obviously this is something that's anything from there's glass on the stage to how do I get paid correctly if I'm an independent contractor, to I suspect human trafficking. So there's a really wide range of issues. So in just kind of on a technical level, as an intake procedure, what do you see as an intake procedure for the hotline?
Chair Hovey, Representative Fagan, the idea is that you have someone on the other end of the line who's an advocate, whether that be a social worker, someone who's worked in the industry before, or someone who's worked at a crisis line. And that person over time will develop the skills to know where to send the information, whether it be anonymous or not. And sometimes that may be law enforcement. Sometimes that might mean you keep the information right there at BOLI and start a process there. Or it might mean that you reach out to OSHA. So, we hope that, the person that's hired to do this job will understand all of the resources available to them and use them in the best way possible.
Thank you. Appreciate you coming forward, and Elle, really appreciate your courage in bringing this issue to the forefront. We believe, or at least I do, and I think I speak for a lot of us here, that all workers have rights and deserve the protections of workers. So with that, thank you so much for bringing this to Salem, and we will hopefully work on this bill. So with that, up next I apologize if I butcher these names, but Martha Calderon, Paris Mower, Hoover, geez, and Ray McMillin. I could read that one. Ray's a good printer.
Thank you, Chair.
She works in my district. I know where her club is.
Good morning, and if you would just remember to introduce yourself for the record before you speak.
I guess I'll go first, if it's okay. Good morning. My name is Martha Calderon. I am the NASW, MSW student representative for NAS Oregon chapter. I'm here representing NASW in support of House Bill 3059. As a social worker, I believe in our mission and our profession, which is rooted in a set of core values. One of our 6 core values is the inherent worth and dignity of every person. This can be found in our Code of Ethics. I brought it in case anybody wanted to see it. I ask that you support 3059 in providing a safer working environment for the people working in the live entertainment industry. The testimonies you've heard and you're beginning to hear and you will continue to hear will bring into perspective the unsanitary and unsafe circumstances that these artists find themselves in. I applaud the folks bringing this issue forward and I thank them for the courage. NASW calls upon you to support House Bill 3059, and we thank you for your time.
My name is Paris Hoover, and I live in Portland, Oregon. In order for me to tell you why I'm here, I must tell you a bit about myself. I grew up in Salem, Oregon. I was a member of a lower middle class nuclear family, and my father was a small business owner. My mother worked full time. I went to grades K through 12 at Salem Kaiser School District and graduated with my diploma on time. And since moving to Portland in 2007, I've been performing around town as part of a musical comedy duo. I've also worked in other capacities on other local music, comedy, and burlesque shows, all while working low-wage jobs in the customer service sector. Last June, at the age of 26, I decided I would give being an adult entertainer a try. I did not anticipate that that would lead me here today. When I heard that there was a group of lobbyists working on a bill, I initially wanted to go in order to show support and connect with and learn from other members of our very large and diverse community. At the first meeting I attended, there were about 30 performers from venues in Portland and surrounding areas. Listening to them voice their concerns about issues within the industry and other states' attempts at regulation, I began to realize that any legislation could potentially harm performers who rely on this income in order to support themselves, their families, and who honestly enjoy the work that they do because it allows them many freedoms. I was not planning on testifying until I spoke with a member of a nonprofit organization who was concerned that the working class dancers, such as myself, would be underrepresented in these proceedings. I decided that if somebody had to stick their neck out, I would be willing to do it, given that I do not have as much to risk as somebody who's been doing our job for years. The following testimony is based on personal experiences and feedback received from a number of current and former industry professionals who could not or would not speak here today. Recurring abuses that are commonplace are ones that no other industry would allow, and performers have adapted to a broken system because they are afraid that government interference will infringe on their income and the amount of control they have over how they earn it. The main thing that industry professionals agree on is that we do not want our industry to be restricted or stigmatized any more than it already is. Oregon is one of the only states that protects artistic expression in venues that serve alcohol, and for some of us who are born here, this has always been a source of pride. Unanimously, we want this form of expression to continue to be protected, and we want our livelihood to remain intact. But there is an imbalance of power in the workplace, and little to no action that performers can take without fear of retaliation or possible career suicide. Most clubs treat their performers fairly well. The extreme cases that make the headlines are few and far between. However, misclassification of independent contractors and health and safety issues are commonplace at the majority of establishments. We do not want clubs to be shut down, causing people we work with and care about to lose their jobs. Most of us do not want to be classified as employees because we do not want to be treated as employees. We simply want our rights as independent contractors to be upheld, and House Bill 3059 is a step toward putting more power in the hands of the performers so that they can ensure that their places of business remain safe, clean, and fun entertainment establishments. Working in the nightlife industry provides us with an environment where unique personality and sense of humor is appreciated and rewarded, and as independent contractors, we are entitled to and have more freedom. For the record, I love my job. It took me 8 years of trying different kinds of professions before I found something that makes me happy, I'm good at, and allows me to support myself sufficiently. All I want is for performers to have a resource that informs them of their rights and a way to report violations of those rights or any other dangerous activity, and I ask you to support House Bill 3059 to do that.
Thank you. Go ahead.
Chair Hovey, members of the committee, thank you very much. My name is Ray McMillin. I am
And can you move that mic away
sorry.
from you a little bit or scoot back? Thanks.
See, I have done this before, and I'm just not paying attention. I'm originally from Salem. I went to Portland State to earn a master's degree, and I basically focused in media communication, psychology, social sciences, and entertainment. And after obtaining that master's degree, due to the nature of the economy, I've been a strip club DJ for about 7 years, in addition to working with other live entertainment such as bands, comedians, disc jockeys, and variety shows, or burlesque shows as you call them. Something I like to state about myself is I've worked at over 24 clubs. I've been fired from one. So this is something that I choose to do. And when I leave these clubs, it is never because of pay. I am not a dancer. I just work around a lot of dancers, and I also work around a lot of things that are not associated with the adult entertainment industry at all. Every single club that I've left has the common theme of an attitude being taken toward live entertainers that sort of puts us off as disposable. And it's a gray area between 1099 contractor and W-2. And like Calvin Hayes said from PAC, where this is not an issue about wage laws. What it is the fact that we are untrained, we have no experience, and we have no resources to reach out. When I say we, if you're looking at me thinking he does not appear to be a dancer, the concerns that I've seen in the strip club industry are parallel to those that I see when I go to do live comedy, when I set up bands. I'm talking Christian rock bands, G-rated entertainment. Sometimes the same venue has a stripper pole attachment in it. So anything that affects an Oregon entertainer is going to be canonized by whatever's happening in the adult entertainment industry. An analogy I like to throw out is maybe you don't drink wine, but if you are a grape farmer, the Oregon wine industry is important to you. Therefore, if you're not a dancer, or if you're adamantly opposed to Portland liberalism, etc., if you have any interest in picking up a piano at your church, you need to respect the canonization of the Oregon adult entertainment industry as setting the bar for entertainment across the spectrum. With that being said, I do currently work as a live show producer, a stand-up comic, and a disc jockey, and I find myself having to pay the same dues. So when I go down to Medford, I play a stage where there's a nail sticking out of the ground. And when I approach the bar owner, that's the industry. And I could think of no other job where this would be allowed, where I have no resources and where my peers have no resources. Again, echoing that I am not a female working in a very unequal system. I work clothed, and I still see the same effects on fellow stand-up comics and DJs and burlesque performers and my nephew's Christian rock band that the dancers are trying to advocate for today. So with all respect for the adult entertainment industry that I've grown up in, I would like to say that this is not an issue of, quote, strip clubs. This is an issue of strictly live entertainment. Another concern I have is the venues are virtually off the radar. If I go to some sort of regular workplace and something happens, I can Google who owns it, where this business is licensed out of. In strip clubs, it's often talk to Rick. That is the most specific instructions you're going to get when dealing with any kind of workplace hazards. The stories about the poles and the nail, this is not fringe, random examples. This is the norm. Working in a club where I get paid on time by an owner who knows my name and has a 1099 contract form has happened twice in about 12 years. Once in Salem, once in Portland. Other than that, I've never been on the record as anything other than DJ Hazmat in a situation where people are naked and doing acrobatics while drinking. Which brings me to my third point, and that is the Oregon Liquor Control Commission is a private organization. Whether or not we like to accept it is basically a private organization. When a minor, read 18 to 20 years old, is caught drinking in one of the clubs I've worked at, or any of the clubs I've worked at, if she were to fall over and hurt herself or himself, doesn't matter. The biggest issue is the OLCC. And if the owner finds out they might be facing a fine, they sober that minor up, they put her in the back, they take care of her. If a girl's 22 years over and she's been intoxicated and falls over, tough expletive. So the fact that the Liquor Control Commission is a bigger threat to people that are putting naked human beings on stage for other people's entertainment is shocking. The OLCC should not be doing a better job keeping our entertainers safe than the state. And as far as putting out the agenda of a hotline or some sort of advocacy line, I'd like to make two quick points before I get off the mic. One is that 911 receives phone calls for horrible things. Like you're asking, how do we separate human trafficking from Destiny didn't pay her stage fee? Right. And that's a good question, but that is also the cost of doing business to make sure people are not being subject to to human trafficking. And personally speaking, as a previous volunteer for crisis lines, I have no problem spending 8 hours on a phone call talking people down from a ledge if that saves one person from being trafficked. I have lost dozens of friends to this industry. I don't mean heroin overdoses, I don't mean drunk driving, I mean lost. I have friends that are missing that have no record of where they've gone. Last place they were seen is in some club, 137th and Gunshot out in Portland. You never heard from them again. At a construction site, we're not trying to unionize here. At a construction site, there's signs from OSHA saying what you're allowed to do to your employees. If I contract someone to do my landscaping, I cannot treat him or her with the same amount of negligence and disposability that live entertainers are being treated with. And to close on this, we are not some fringe group, and I understand that I might be an anomaly saying that I am pro strip club industry. If you are disgusted by it, that is fine. But I'd like you to consider what you do like, jazz music or golf or whatever it is you watch. The Oregon strip club industry, we have more strip clubs per capita than anywhere else. So what the Oregon strip club industry says about entertainment is what Oregon says about entertainment. And I see a lot of the same trends working as a stand-up comic that my peers do working as naked entertainers. Those two jobs have nothing to do with each other. One of us should be introducing the other one. We should not be worried about glass and nails. Thank you very much for your time.
Thank you. Appreciate your testimony. I should have asked this before, but I was kind of curious that if you get hurt and you're an independent contractor, you have workers' comp?
Not that I know of. I was never told of any sort of precautions or anything, or any sort of recourse if I were to get injured on the job. It's just more like if you can't dance, then you can't work. You need to go home. I have had friends who've seriously injured one of their shoulders, or another friend ruptured her ACL while doing pole work, and she needed to be in a knee brace, but she could not wear that on stage, but she could not afford to take time off in order to rest her knee because she relied on that income in order to take care of her children.
If I may interject, Chair Olvey, members of the committee, we have a group called the Cupcake Girls. It's basically a volunteer organization that goes from club to club, providing them with things like Band-Aids, ointment. And that's the perspective we're trying to put in here. It's we are not even thinking about workers' comp or health insurance. We want to know where the Band-Aids are. So we'll work up to everything else later.
Not seeing any other questions at this time. Thanks for sharing your perspectives on this, and I appreciate you coming down and enlightening us a little bit.
Thank you for having us.
You missed a very interesting one.
Up next, I have Claude D.
Took a lot of pokes.
DeCourcy.
Oh, yeah.
That was tough. And Joel Shapiro.
Portland, the mayor, former governor. Definition. Yeah, it was interesting. It was kind of awkward for a school.
Who's that?
Same guy,
Oh, okay.
Yes, I am.
Did you introduce yourself to the record, please?
Hi, Chairman Holvey, Vice Chair Barton, and Kennemer's not here, but him as well. My name is Claude DeCourcy. I represent the Oregon Association of Club Executives, which is the adult trade association that represents operators, owners, and up until recently, everybody else who is associated with this industry. I am here in support of House Bill 3059 as the industry representative, although not everybody will agree with as an industry. I think as an industry as a whole, we think this is a good and appropriate bill to go forward. Listening to some of the comments from my industry representatives, Elle, Ray, Paris, I noticed and took some notes as they were talking. Ethics was raised, and you know that sometimes raises an eyebrow. Ethics in what we do, and it's not ethics in what we do as far as nude entertainment or entertainers doing their making money the way they make their money. Ethics in how we conduct ourselves, ethics in how we do our business, ethics in how we treat the people all people who work in our industry. That's being entertainers, managers, operators, bartenders, waitresses, anybody, customers, patrons. I think that's the key, is that we represent ethics in what we do. It's a very important thing. And as an operator myself, I operate with an ethical lens that determines, in my personal opinion, what is right and what is wrong. And listening to some of the issues that have come across, nails on a stage, broken glass, mops being used to mop up bathrooms as well as a stage that entertainers use, that is not an ethical or a practical, it's not anything when it comes to business and what we do. And that should not be acceptable by any means. Listening to that, it's sickening. The issues that are raised are extreme and are troubling. And I myself, somebody who represents the industry, kind of cock my head and go, how could that happen? How is that going on? And it's been brought to my attention that what my normal is not necessarily what other normal is. And we hear that where some of the people who have testified have said that there's no training. There's no, what do I do if I step on a nail? And to us, that may seem as commonplace, well, go get a Band-Aid. Well, where is the Band-Aids? That doesn't seem like a good operation. And to allow our entertainers, which is the basis of our business, without them, we are nothing. We are just a bar with overpriced liquor.
Mistakes.
And that's, that's true. That's we don't want to. It's funny, but it's the truth. I mean, what I do is I manage a bar with nude entertainment. That is what I do, and I love what I do, and I love the people who I work with. I love the people who represent it, our industry, from attorneys to operators to entertainers. And it is troubling to us as operators to hear this. One point I want to make is that these issues are these operations that have these issues are a small percentage. The majority of operators and operations in the state of Oregon would not accept any of these conditions as normal. The issue is that let's use the analogy of a rotten apple ruins a bunch. And that's what we have right now. We have a couple rotten apples that are causing this issue, and to cause us to all be here today talking about this. We don't want to see irresponsibility in an industry that's already scrutinized and criticized so much. It is not something that we want. We don't need another issue to bring us out in the open. Well, most operations, and I'm just speaking candidly here, most operations care, and we try to make sure that everybody is taken care of. I would not be here today if I did not think this was an issue that we need to take care of and we need to be around and think about. I'm very upset that we got to this point. And not that to this point that we have come to you to consider a bill, but to the point that our entertainers had to get together, and they couldn't call me, they couldn't talk to their manager and go, hey, there's a problem. So the problem isn't necessarily that there's glass on the stage or the pole isn't connected securely or they don't know where the Band-Aids are at. The problem is that people didn't care enough to actually tell them what they can do, where they can do it, how they can do it, why they can do it. So I support this hotline in 100% as my official position as president of the trade association, as my personal position as a manager who works at these venues. With that being said, I will finish and let Joel speak.
Chair Holvey, members of the committee, thank you for hearing these bills. I'm Joel Shapiro. I'm here because I have worked on the issue of human trafficking for about the last 6 years, starting at the federal level when I served as chief counsel with Senator Wyden, and we introduced the first bill to focus on domestic sex trafficking of minors. When most people hear the word human trafficking, they think immediately of places like Southeast Asia and Eastern Europe. And I'm glad that we're here to talk about the issue of how people are exploited within the United States, because the highest volume of people who are trafficked in the U.S. are vulnerable teenagers and overwhelmingly women, females, girls. And so this bill is not explicitly about that, but I'm glad that you're hearing some testimony because we have I'm here to give you a little bit of the background. And during the last legislative session, I worked closely with Representative Tomei, who put together a work group that met from the end of last session through the interim. And that consisted of service providers, state agencies, law enforcement, to try to figure out how we can continue to make progress on this issue, which we have been doing in Oregon. And the members who serve on the Judiciary Committee, and Representative Barton is here, have done a lot of work on this issue, and particularly Representative Barton, and we thank them for that. And so we had a chance to talk with the NASW folks. Caleb and Courtney came to some of our work group meetings. That work group transitioned from Representative Tomei to Representative Huffman and Representative Taylor, and there have been some other legislators involved as well. But we know that there are many venues out there that are not having an issue of human trafficking, and there are some that are. And so I'm not here to try to paint with an overly broad brush, but we're necessarily talking in generalizations. I do want to mention, I think probably the members of the committee are familiar with the instance that happened in Stars in Beaverton, where there was a 13-year-old girl who was being trafficked out of the club. Both one of the managers of the club and her pimp were prosecuted in that case. It wasn't until she was removed from that situation, had been at a shelter in Arizona, because at the time we didn't have a shelter in Oregon. We now do, that was funded by the legislature last October in the special session, and is now operating. But there are not enough resources, and it wasn't until this particular girl was in a safe place and had gone through quite a bit of counseling and treatment that she could come forward and explain what had happened to her, and it was linked back to this club. I was contacted by KGW when the story broke, and the reporter said, "Can you believe that this was going on?" I said, "Yes, I can believe this is going on, because this does happen. This is not an aberration. There is a risk of people that are in the adult industry being exploited, and people, girls who are underage, that the venue of a strip club can be used." So what I'm here to say is that anything that we can do to raise awareness and provide resources that people who are victimized can find some avenue to try to get some help and get some resources will be helpful. I don't think that these bills are a panacea. They're not gonna cure everything, but I do, and I'm not even here to say that these bills are perfect, because I'm not an expert on live entertainment venues or the adult industry across the board. I've worked in service industries. I've worked in restaurants. I know that things can vary a lot, depending on who's there, who the manager is, how things run. And so, to the extent that more avenues to try to get some oversight are available, I think that would be helpful. Why do we not have enough oversight right now? I think there are a number of reasons. The Oregon Constitution provides very broad protections, as you've already heard in this hearing. So to focus on one particular segment that provides adult entertainment is probably not possible, under equal protection. And that's why these bills are crafted very broadly, in my opinion. And BOLI is a complaint-driven agency that does not have the resources to go out and see what's going on every day or every month or even probably quarterly. But I do think that providing a poster, providing a hotline, and providing some licensing and oversight will be helpful. Thank you.
Thank you. You know, I wanted to bring the agencies up, and we're running out of time. I just have one question. I guess, and either one of you can answer it. I know a lot of these entertainers are you know, want to be independent contractors, and you know, for whatever reason they get, you know, tip money and things like that. But I'm curious, you know, as an independent contractor, they probably, you know, are missing a lot of the employee protections that exist as an employee. So how do you determine if an individual entertainer, when you employ them on a basis, is an independent contractor?
Well, there is the Boley test, I believe. Most operations within our industry will, you know, we don't, and I can't speak for every operation. I can only technically speak for the operation I have control over, which is what I do. They make their own schedules. They pick when they work. They come and go as they please. They do, you know, they act as independent contractors. The protections that
So
are
they work for other.
They work for other venues. They can. I mean,
well.
it is a pretty good gig when it works right. The protections that I'm allotted as an employee, that doesn't necessarily transfer over to them. I can speak from experience, though. When an entertainer has hurt themselves while performing on one of our stages, we usually do everything we can to cover their medical costs, just because that's the right thing to do. Now, not every employer is going to do that, or every club operation is going to do that. But I mean, if you are an electrician and get electrocuted at a job site, what is your recourse? You know, do you sue PG&E? Do you go after the people who employed you? The right thing to do is just to take care of those who get injured while in your operation.
All right, thank you.
Yeah.
I'd like to go ahead and bring up Michael Woods from Oregon OSHA, and Paloma Sparks, if she's willing, and maybe somebody to represent the workers' comp side of the world. Just
Teresa, excellent.
Teresa's always a good sport.
she is a good sport. So. Thank you for signing up to testify. And I suppose I'd, you know, open it up. I know Joel or Michael actually signed up to testify, so maybe we'll start out with his short testimony first.
Chair Holvey, members of the committee, for the record, my name is Michael Wood, and I'm the administrator of the Occupational Safety and Health Division of the Oregon Department of Consumer and Business Services, which, for probably obvious reasons, we shorten typically to Oregon OSHA. And being perfectly capable of taking a hint, I will let you see my written comments, and just note that as Chair Holvey has already indicated, the primary issue for us is the employer-employee relationship. If the employer-employee relationship exists, we have jurisdiction. Our jurisdiction isn't limited to particular industries such as construction or manufacturing. We broadly have jurisdiction over workplaces where employees are exposed or may be exposed to injuries throughout the state. And the test for us usually comes down to issues related to direction and control. I will also say that generally, it is not unusual when we look at what the employer believes to be an independent contractor relationship, whether that's in construction, whether that's sometimes in manufacturing, housekeeping, any number of areas, that we conclude that in fact there is direction and control and there is an employer-employee relationship there, and we act accordingly. We are able to take complaints. We do respond to complaints. We also do scheduled inspections. This particular industry, in our existing scheduling system, we would inspect the average place of employment once every 40 years. So I wouldn't say that based on our scheduling system it's particularly robust. That is actually slightly higher than average, but the
4 years? 40, correct? 40?
Longer than I've been alive.
40.
Oh my God.
Yes.
Is that typical, or is it because of the employer-employee relationship?
It has nothing to do with the employer-employee relationship. It's based on factoring in various injury data, fatality data within the industries, looking at the industrial classifications. And so, for example, for a foundry, we would typically inspect a foundry, which is in our highest risk category. We would typically inspect those a little less frequently than once every 3 years. So it's not, even in our highest risk industries, the notion that we would be there monthly or quarterly isn't necessarily the case.
Whoa, you just sparked a whole bunch of questions here. First, where do you get your funding? No, I'll listen. Representative Fagan.
So my question is pretty technical based on what we're doing here with this bill. So we're creating a hotline where I would expect to maybe see a greater volume of complaints to OSHA. When you have your formula for how frequently you inspect a place, is it literally complaints about that workplace, or is it complaints by employees at that workplace? So, for example, if dancers were to begin to call, but you were to find that, a certain volume of them were not employees, would those not be counted as injuries on the workplace for purposes of your, how often you inspect it?
Chair Holvey, Representative Fagan, the scheduling system that I referred to is actually separate and apart from the issue of a worker complaint. So a worker complaint, depending on the severity of that complaint, the severity of the hazards alleged, the issues we're looking at, will always result in an inquiry that we describe as an investigation or perhaps an inspection. The point I was trying to make is that absent worker complaints, it's relatively unlikely that we would be doing inspections of these establishments on our own initiative.
Every 4 years.
Teresa, just a quick question before I move on, so I don't lose track of this one. Do independent contractors in any scenarios receive workers' compensation insurance?
Mr. Chair, for the record, Teresa Van Winkle, Senior Policy Advisor for the Department of Consumer and Business Services. In general, no. The answer is no.
Yeah.
Now, so for, if you would like, Mr. Chair, I can offer for you, for lack of time, without you testing me on the ins and outs of independent contracting, I can provide to the committee a primer from the website in regards to the different agencies and their litmus tests on what constitutes independent contracting.
And along with what kind of benefits are available, or what kind of requirements are if there are any, I suppose, of independent contractors to provide themselves with insurance. Anyway, who is next? Representative Kinnemer.
Thank you, Mr. Chair. Just if I may comment, having professionally worked with a small number of these ladies in the very difficult transition to a more traditional life, I would say the most profound thing we could do would be to help them have status as workers, as employees. They have no rights, and they have no backup, and being paid under the table and all these things that go on undermine their ability to transition into a, if I may say, it may is a value judgment, but a more favorable or a more positive lifestyle.
A little bit of a value judgment there, perhaps. Representative Barton.
Thank you. A question of you, Mr. Wood. So first of all, I want to acknowledge, we do this to you all the time. The legislature, we don't invest enough resources in your department, and then we complain about you not doing it. All right? I get that. So I am sympathetic. Having said that, it seems like the current approach that your department uses seems to assume, I suppose, the reliability of the data. And there might be certain industries, for example, where, for various reasons, people might be less likely to report to a government agency that there are about unsafe work conditions or injuries. Is there anything that your organization can do to account for that potential data discrepancies?
Chair Holvey, Representative Barton, I think you raise a very good point. The data sources that we look to assess risk across an industry include the workers' compensation data and data gathered by the Bureau of Labor Statistics. Now, of course, those both depend on an assessment being made that we're dealing with an employer-employee relationship. To the extent that injuries occur and that everyone believes they're outside of that relationship, even if in fact that's not the case, or under law that's not the case, it's likely that those would not get reported. And I think that that is a limitation of the data. One of the struggles we have is we have, both as a good practical measure of trying to target our limited resources and also a statutory direction, we have to identify those places of employment that are most likely to be unsafe. And it's difficult to do that without some data source that we could draw on. If there is a way to access other data, we certainly can look at changing the methods we use in order to assess those industries.
Brief follow-up?
Real briefly.
So, thank you for the answer, Mr. Wood. What can this committee or this legislature do aside from, you can see our reactions. We care about safety of everyone, of entertainers and everyone. What can we do to help you perhaps take a look at this industry and see what safety, what we can do?
Chair Holvey, Representative Barton, that's an important question that I think would require a thoughtful answer, and probably an answer that would require more thought than I'm able to give it right now, but I'd be happy to follow up with you.
Thank you.
My answer would be a budget note. Representative Widener.
Thank you, Mr. Chair. I think as we're looking at this, I'm seeing lots of different things come into play, and Mr. Wood, you can let me know if this works into OSHA, but I'm almost seeing some things with the county health inspector. Like when I had a restaurant, we pay $600 a year to the health inspector. They come in twice a year and they would make sure that everything's, all the food prep, all of that stuff's done right. And I'm wondering if we should be looking at other agencies, whether it's OLCC, it looks like we're missing the boat on multiple groups coming in and looking at what's happening in these facilities and come up with the plan for handling these clubs and the way they should be maintained and ran, all the way from food safety to liquor control to, even police with the trafficking and everything. And that's where I actually commend Representative Barton for the sex trafficking stuff with the signs to be put up in these places with the bill that he's worked on a couple sessions ago. So I don't know what your thoughts are on this, but how involved OSHA wants to be. I know we need you there looking at these facilities, though, and what we need to do. It might be a fee that we just do to the whole industry if you're a registered sex club, or not, sorry, what, live entertainment facility, you pay $600 a year or whatever it is.
Chair Holvey, Representative Widener, it's certainly true that there are other regulatory entities that focus on public health issues. It's also true that when you look at those particular establishments, jurisdiction over the health of the workers still ends up tending to fall into our lap and being handled outside the context of those twice yearly inspections. And it isn't something that we're necessarily resourced to staff at the same level.
Paloma, for the Bureau of Labor and Industries, has this industry, come up in investigations and in determinations of wage claims and/or independent contractor status to BOLI?
For the record, Paloma Sparks with the Bureau of Labor and Industries. Chair Holvey, members of the committee, yes, we have conducted various investigations. We receive complaints every once in a while from dancers. It varies how those turn out. In some cases, we determine that those workers are, in fact, employees. Sometimes they're independent contractors. When we have done sort of investigations on our own initiative, the biggest problem that we encounter is reluctance for workers to talk to us about their working conditions.
So in terms of wage claims, if a worker comes to you and they're actually an independent contractor, their remedy is not through BOLI for recovering money as an independent contractor?
That's correct. We can't do anything in terms of if they are not employees, we cannot help them.
Guess I'll turn to my labor attorney and see what independent contractors do besides getting an attorney and going to court.
They have contract remedies. They're contractors.
Right.
I mean, that's what they have is contract remedies.
Right.
If they have a contract.
Yeah.
But, so any other questions of our agencies on this? Thank you. I appreciate you being willing to come up and just sort of highlight a couple things for us. It appears this issue is complicated for certain, but I'm hopeful we can make some improvements for this industry. Thanks a lot.
Thank you.
No one else was signed up to testify. With that, I will close the public hearing on House Bill 3059 and close the public hearing on House Bill 3060. Any other news? Good of the order. We were carrying over the 2 work sessions I announced previously. I'll go ahead and finish that. They were carrying over House Bill 2805 and House Bill 2386. With that, I'll adjourn the committee, House Committee on Business and Labor.